Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. The court will hear argument in 3 cases this morning. First is 2174, Industrial Specialist against Blanchard Refining Company from Galveston County and the First Court of Appeals District. Justice Lehrman is not participating in the decision of that case. Next is 2700, the City of Fort Worth against Pridgeon from Dallas County and the Fifth Court of Appeals District. And finally, 2727, Taylor versus Tolbert from Harris County and the 14th Court of Appeals District. The court has allotted 20 minutes per side in each of the cases, and we'll take a brief recess between the cases, finishing them before lunch. The arguments are being webcast live on the court's webpage this morning and will be available later in the archives. We're ready to hear argument in 2174, Industrial Specialist against Blanchard Refining.
May it please the court, Ms. Barger will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. Justice Heck, and may it please the court. Marathon's attempt at indemnification for a voluntary payment of $86 million is against Texas law and attempts to rewrite the parties' agreement. Marathon settled the one thing that they didn't contract for and the one thing they cannot seek indemnity for. ISI's position, however, honors the contract as written and the policy concerns in this court's precedent. For 2 reasons, we ask this court to reverse the denial of ISI's motion for summary judgment here on permissive appeal. First, under this court's opinion, Ethel applies. The parties seeking indemnity for the consequences of their own negligence causes injury proximately, jointly, and concurrently with the indemnitor must meet the test. Here there is no dispute. Marathon settled its negligence, and Marathon is now seeking for their concurrent negligence for a single harm. Therefore, the indemnity provision is unenforceable as a matter of law. For a second and independent reason, Jenkins precludes Marathon's claim, both legally and factually. As this court held in Jenkins, a party cannot settle more than its proportionate share of a common liability. That's what happened here. If we refer the court to the tab 1 of our bench book, slide 2, or slide 3, Marathon settled its proportionate share. And if you look at the releases that are in bench book, tabs 3 through 5, and forgive me, there is one more agreement that was inadvertently left out, which is at Clerk's Record 344, which was with Innovative Ventilation between Marathon. That was another contractor. So it is clear that Marathon was not settling anything other than what it legally could settle under Jenkins. So therefore, under Jenkins and Ethel, Marathon's claim for indemnification should be barred. Turning to our first point, this does not meet the express negligence test. I think to start with this court's precedent gives a background. Initially, this court in Fireman's Fund in 1972 had a clear and equivocal test. That clear and equivocal test was unworkable and unpredictable and caused a lot of confusion in what that meant, what was the party's intent, looking at the circumstances. So 15 years later, this court decided we should, with a better, stronger test, overrule Fireman Fund and now requires an express negligent test for joint and concurrent negligence. In fact, that court specifically held indemnities such as Marathon here, seeking indemnity for the consequences of their own negligence, which proximately causes, jointly and concurrently, with the indemnitor's negligence, must also meet the test. We're not saying that they couldn't have contracted for comparative indemnity, but they didn't here. This court has since only a few more times addressed the express negligence test. In Atlantic Richfield Company, in that case, they found the language was sufficient, quote, including but not limited to any negligent act or omission. Important in that case, this court held the better policy is to cut through the ambiguity of the provisions and adopt the express negligence test. This court in 1994 in Payne versus PPG analyzed some language that was, quote, irrespective of whether the indemnity was concurrently negligent, and concluded concurrently negligent. That was sufficient, and that obviously expressed the party's intent for concurrent negligence. Next, the court addressed in Fisk. Fisk was another independent where this court held there was no indemnity, and quoted, quote, from that case is, without a clear agreement, it would also leave indemnitors vulnerable to indemnities who might settle without admitting negligence. Here,
Counsel, can I ask you before, and I apologize for interrupting your stream, we'll get back to it, but before we even get to all of these merits questions, which are very important, both sides seem to agree that it was what the Court of Appeals did in denying the permissive appeal was wrong. If we answer all of those merits questions, are we essentially setting the precedent that whenever that is so, there is only going to be one appeal and it's going to be in this court? Is there any pathway, you think, to us instead saying that was wrong, you should have taken the appeal, and us to send it to them to address these merits questions in the first instance, the way that I think the statute was originally envisioning the process going?
Yes, Your Honor, I do think there is a pathway. I think the first court, obviously both sides, should have taken this case. Not only did the trial court, who was in the best position, and the parties agree that all of the elements were satisfied. What this court could do is what it did in the Savory case. It could re-emphasize the importance of taking these permissive appeals for efficient early resolution of these controlling issues of law in which there might be some uncertainty. And I think that by re-emphasizing what this court did there, by saying, look, we understand that there is discretion in the rule to refuse these, but if all of the courts of appeals continuously use their discretion, then as this court held, in that case, the whole purpose of these permissive appeals would be thwarted.
But if we re-emphasize it, and then we just go ahead and decide the merits anyway, and what does that do other than to say, well, feel free to deny it, knowing that if we want to take the question, we'll just do the work in the first instance?
I think that, Your Honor, I think that by doing that, it possibly might send a message, or maybe reinforcing the message to the Court of Appeals. For instance, in looking at just the first court and looking at the statistics and the ones that have been filed and denied, most of them have been denied. Very few were taken. And that is routinely through all the courts of appeals. So I think that I don't think it would necessarily set precedent that all of you feel free, because I think obviously the Savory case said we can take it even if the Court of Appeals denied it. So I think that you have the discretion as well if we come up here to deny it.
Do you think it was an error for the Court of Appeals to deny it, or do you just think, well, no, they had the authority to deny it, but this court also has the authority to take it? Which one is it really?
I think it was an error for the Court of Appeals to deny the permissive appeal. I think.
What is the extent of the discretion of a Court of Appeals under our statute? When is it that it's actually an abuse of discretion to not take it exactly?
I think that's unclear, Your Honor. I think that I think there could be some clarity there. When would it be an abuse of discretion? Or, and that's our second point, if the Court of Appeals is going to deny these, perhaps they have to give more sufficient reasons. versus you just don't meet the elements. Why didn't we meet the elements? Is there not a controlling issue of law? Is it a fact issue? Does it not maybe terminate the entire litigation? For instance, if you were taking a permissive appeal and there was negligence and gross negligence, but gross negligence wasn't up on permissive appeal, that wouldn't terminate the litigation.
So
I
the,
think
the statute says if the factors exist, the court may take the appeal. It sounds like maybe you're saying that if the factors exist, or maybe if they clearly exist, or something like that, the court shall take the appeal. And I'm trying to figure out how we get from the statutory language may take the appeal to some kind of rule that requires the courts of appeals to take these in certain circumstances.
I think that to direct a Court of Appeals to take something in certain circumstances, it could take, let's go back to what the statute used to be. The statute used to be that if the parties agreed, you could take the permissive appeal. There wasn't the discretion. So if the parties are agreeing that there's a controlling issue and the parties want the early resolution, then I think that there could be something to be said to the Court of Appeals to look at it a little bit stronger, to look at the issues, or at least give the litigants of this state some guidance as to when a permissive appeal might not be met. So,
could that be achieved if we, for example, said, well, maybe it's not an abuse of discretion to decline it, but it's an abuse of discretion not to explain why you're declining it? Like we do, for example, in Poole versus Ford Motor Company cases on factual sufficiency. We don't review that, but we require the courts of appeals to explain why the standard is or is not met. And it seems like we've got a standard here in the statute. And so can you think of any other examples or any reasons, pro or con, why we shouldn't require the Court of Appeals to explain, if they're applying that standard anyway, which they said in their opinion they were, why shouldn't they have to explain why they think it's not met?
I think the Court of Appeals should, and I think that that's one of the arguments that we're making here, like under Rule 47.1, where it says that any opinion disposing should give some sort of reasons, except a denial of a mandamus. So I think that would give the litigants and this court some guidance. So if the Court of Appeals gave reasons why perhaps it didn't, I'm sorry, Your Honor.
We have statutes that grant us jurisdiction, this court jurisdiction, to hear cases on a petition for review, and standards that lay out, and that's changed not too long ago, but that governs our appellate jurisdiction. Yet we deny 9 out of 10 petitions for review. Is it an abuse of discretion when we deny a petition for review? And if not, what's the difference? And then secondly, we don't explain why we deny a petition for review. We don't write a little opinion on every single one explaining why we're denying it. Is that an abuse of discretion? And if not, what's the difference between, and I don't mean the difference in a practical well, but it gives, information to the parties and to other courts why you're doing it. Statutorily, what's the difference?
Statutorily, the difference, Your Honor, I think it would not be an abuse of discretion in that situation, but it would be an abuse of discretion in the permissive appeal, because in your analogy with the denial of the petition, the litigants already went through one phase. Obviously, with the trial court, they went, in most situations, they're getting an opinion from the appellate court, and this court has the discretion to decide, is that an issue that's important to the state? Now, the permissive appellate statute, what the legislator intended, as this court has said already, is to help those parties resolve issues that are controlling, uncertain, to maybe end things so we wouldn't spend all this time litigating. And now we're here, I guess we've been litigating this issue now for 4 years. So I think out of judicial economy, we would like this court.
But it would help the parties for us to decide this case. Would we have abused our discretion if we had denied the petition in this case? And would we have abused our discretion if we had done so without issuing an opinion?
Your Honor, we're asking this court to direct the Court of Appeals, which is really the level that should be deciding these first, because we understand that the court's dockets are heavy, and we understand there's a lot going on. We understand that essentially the reason that these permissive appeals are taken is for these litigants to save time. And so we're asking this court to reiterate what it had said in the Savory case, that if the Court of Appeals used its discretion every time to not deny it, then the purpose of the legislature intended would be thwarted. So I'm not saying that this court, if this court would have denied it, which this court in fact initially had procedurally, denied the petition, and only then after motion for rehearing gave us granting on the briefs. I'm not going to say that that was an abuse of discretion initially. I'm saying that our position here is that the Court of Appeals should have taken it because the parties had agreed that the statutory elements were met.
Going back to the merits, do you want to address the Gulf Insurance case that I think is the main case the respondents rely on, saying to the extent there's any question about the express negligence test, they've met it in this case?
Yes, Your Honor, I would like to address the Gulf Insurance quickly. In that case, I think it's very factually different. In that case, I think that there, where the court had said that the express negligence test wasn't applied, there was an agent, there was a car dealership, there was knowing misrepresentations, and those knowing misrepresentations basically of the insurance coverage, if I'm correct, and the court in that case specifically held, or this court held, that the parties didn't intend for there to be indemnification for some agents' misrepresentations that were basically, there isn't any issue that there was concurrent negligence in that case. So I think that case is very distinguishable. And I think the other authorities apply here. Your Honor, I will.
Any other questions?
Any other questions?
Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Maddox will present argument for the respondents.
May it please the court. I'd like to focus on primarily on two issues. One is whether this court's decision in Jenkins does or should require a settling defendant to forfeit its bargain for right to indemnity by settling. And two is the express negligence rule.
Can you start with the appellate jurisdiction?
I was about to get to that, Your Honor. I was about to say that I want to start, though, by noting that the parties agree on one thing, which is that this is a case that is particularly suited for this court. Two reasons for that. One, indemnity agreements are frankly very important in Texas to our industry. The legislature has recognized indemnity agreements in this situation where we've got a subscribing employer who otherwise can't be sued. And two, the decisions that are at issue are virtually all from this court. And not just that, but they are policy-based decisions from this court. Now, as to the court clearly has jurisdiction to decide the merits of this case. And I think what Justice Young's question is, should the court instead send it back? And of course, the court can do so. And we would submit that the area of permissive interlocutory appeals is also deserving of some guidance from this court. To your question about abuse of discretion, I think that the court did abuse its discretion here. This is sort of the quintessential case that is deserving of a permissive interlocutory appeal. The Court of Appeals should have decided it.
But even if this is the quintessential, the most perfect case for when the legislature wants to allow permissive interlocutory appeals, the legislature merely allowed it. It just says the courts may take up the appeal. There's no obligation to do so under the language of the statute. So how can it be an abuse of discretion when the legislature merely said you may do so if these elements are met?
I think this is where some of that guidance is needed from this court. When does, the court talked about permissive interlocutory appeals and gave some guidance in the Sabre travel case, but it is unclear to litigants and attorneys when that abuse of discretion occurs.
Could it be an abuse of discretion to fail to follow a particular process, even if you have an option as to what the end result should be?
It would. I mean, that's the quintessential
So why couldn't it be an abuse of discretion for the Court of Appeals not to explain itself on why those standards aren't met?
I think
even if it has the option to go either way at the
right,
end.
and I think it may, and I think what Justice Busby, what you're getting to is the analogy to some of the other cases where this court has said, well, the Court of Appeals needs to explain what its reasoning is. We've cited the rule. I think, quite honestly, there's a bit of a gap here, and there's no rule like there is for a petition for review that you can deny without reason. And to your question about did you abuse discretion, I don't know who grades your paper.
What legal standard requires the Court of Appeals to explain its decision not to take up a permissive appeal? What legal statute, rule, court opinion, any legal standard required the court to do that here?
That's the question, Your Honor. The Court of Appeals used the memorandum opinion rule, and that the court has held, requires some basic reasons. And that's the answer to your question. My client, like most clients, would like to know why the court ruled like it does. We recognize that, of course, courts of appeals are also overburdened. There are several members of this court who probably understand that issue better than I do. But we do believe that this is deserving of this court providing some guidance to litigants, to attorneys.
Do you take anything significant? I think that everybody agrees that our statute was modeled to some extent, at least, on the federal statute, 1292B. And in our statute, it says an appellate court may accept an appeal. The federal statute says the Court of Appeals may, in its discretion, permit an appeal to be taken. Our legislature deleted the words "in its discretion." Do you take that to be meaningful?
In Sabre Travel, this court said that this is an abuse of discretion standard. So as it stands right now, that is the standard, and the question is what constitutes an abuse of discretion?
There's clearly some discretion that has to be brought to bear, but when the legislature omits the phrase "in its discretion," do we think that is a meaningful thing, or do we think the legislature thought that the phrase in the federal statute was surplusage?
May is traditionally seen to be a discretionary, so it probably is surplusage. But I think the question you're asking is does the court have discretion, or is in the sense of an abuse of discretion standard, which we're all familiar with, or can it do it no matter what? It may means that it can do it if it wants to. It doesn't have to have any reasons. I do think
the federal cases have described that the discretion on the federal side is almost unfettered. Do you think that's the standard here? And if it is, does the statement of reasons for accepting or denying the appeal matter?
If it's unfettered, then it's almost unreviewable, and I don't know if it does matter. But I don't think that's what this court said in Sabre Travel, which left a lot open, to be honest. But
Sabre Travel, I think, said that, correct me if I'm wrong, that the way that it survived is because the Court of Appeals cited the standard that the permissive interlocutory appeals statute should be read strictly. That's what it said, I think. Is that right?
I honestly do not remember if the word strict was in there, but yes, at least.
Do you think that's something that is still good law, that we should read it strictly?
I think you should read it, I don't know if strictly is the right word, but also not unfettered. You should read the statute as it's written, if that makes sense.
And so with the legislature passing this new, that strict construction language, I think dates back to the year 2000, when the statute really was very rigid in allowing it. Then they passed this. Does that give us reason to wonder that maybe, and I don't think the parties disputed that in Saber Travel, so it might be open to us for the first time now. Is there reason for us to conclude that the legislature, by so dramatically expanding jurisdiction over interlocutory appeals, no longer wants that to be strictly, but maybe accurately, reasonably, as you said, read the text? Is that something that we should consider anew?
I would submit that the court should read the statute as it's written. It certainly is the case that the legislature has opened up permissive interlocutory appeals a lot more in the recent decade plus.
And one last question from me on this, I promise. If we were to just go ahead and continue to say, well, gosh, the Court of Appeals probably should have taken this, maybe it was even an error for it not to have done it, but we'll just go ahead and do it ourselves. Does that not create a pathway to a direct appeal from a district court to this court? No other court, no Court of Appeals merits decision having been presented that really wasn't the intent of the legislature. Do we not now see that this could become a mechanism to get direct appeals that are actually far more limited than even interlocutory appeals to the courts of appeals are?
Your Honor, I think the court was right in Saber Travel in saying that this would not be a direct appeal situation. I think that the issue here is, at this point, this case is like most other petitions for review. The court has jurisdiction over it. I don't think there's a question as to that. And so the question is this a case that the court ought to decide? Is it important to the jurisprudence of the state?
Turning to the merits,
yes.
What would a trial that would apply comparative negligence principles with the settling defendant, what would a trial look like if we agreed with you that there could be some claim for indemnity?
The jury would be asked three questions, Your Honor. One, was the settlement reasonable? I'd like to go back to that if I can in a second, but to finish answering your question, then the jury would be asked, which of the following, the negligence, if any, of the following parties caused the injuries, and everybody would be listed, and then the percentage question. So it wouldn't be that different than things that the courts do all the time.
How does it look any different than a claim for contribution that we didn't allow in Jenkins?
Well, one of the big differences here is the parties contracted for this. And so the overall policy considerations are very different than they were in Jenkins.
In that because of the contract, your client could settle for more than its proportionate share of liability, and how would we determine that from the contract?
So I think if you look at their demonstrative and that pie chart that they have, that zeroes in on one of the disagreements between the two parties. This court had held over 50 years ago that a settling defendant does not settle its own actual liability. A settling defendant settles its potential risk, and that's certainly the reality. That's what parties do, is they settle the potential risk. Now, the question here in this court now is is this a situation where this court should create a sort of legal fiction, a construct, that's not what we did here. That instead, we only settled our portion of responsibility, because that certainly wasn't reality. The reality is, as the premises owner, with the contractor employer not able to be in the case,
Well, as a responsible third party, right?
Right.
Their negligence would have been submitted.
Their negligence,
to the
yes,
jury.
they were designated as responsible third party. They actually had intervened in the case and participated all the way through, including in the mediation. And so they would have been on the jury charge, yes. But they would not have been, the plaintiff would not have been able to recover because of the workers' comp bar, except for the indemnity agreement. And the indemnity agreement is, the parties, there's two sophisticated parties contracted for this. The workers' comp statute contemplates it. 417.004 says a third party can't recover against the employer unless there's a written agreement. And this is exactly what happened. Now, with regard to the express negligence rule, sure, if our client had wanted to be indemnified for its own negligence, we would have had to satisfy this express negligence rule. I'm sure my client would have loved to be indemnified fully in this case, but that's not what the parties contracted for. The parties contracted for if my client has to pay for something that its negligence did not cause, that's what ISI agreed to cover.
So to flesh out your three jury questions, if the jury came back and answered to number one and said the settlement was not fair, what would be the resulting judgment?
If the settlement was not reasonable,
Reasonable.
that would be the
Marathon would not recover anything.
yes, because that's just any sort of that's the threshold for any indemnification.
If they come back and say yes, it was reasonable. Question number two, they say yes, all these parties were negligent, including Marathon. And question number three, let's say they put 50% of the causation responsibility on Marathon. Your theory, under your theory of the case, is that Marathon would then get $43 million in the judgment?
So
The 50% of the 86 they paid?
anything Marathon did not cause, yes.
So your theory is 50% of that, under those jury findings, 50% of the 86 million reflected Marathon's damages resulting from Marathon's own negligence. The other 50% was damages resulting from someone else's negligence and therefore falls within the agreed upon indemnity. Is that your theory there?
Correct.
Going back then to question number one, how is a jury supposed to decide whether the settlement is reasonable for Marathon to agree to pay this amount when some portion of it, in that example 50%, wasn't even for Marathon's responsibility? How do you apply reasonableness to the question of one party's agreement to pay for damages caused by some other party?
Because that's what Marathon, in your example, had a risk of having to pay the entire amount.
You have to decide it before you know what the percentage is.
Well, and that's, anytime a defendant settles, they're settling a risk, and was it reasonable to do so? It's a business decision. And if in your situation, if a jury finds,
So in other words, the jury would have to decide whether 86 million was a reasonable value relative to the risk that Marathon would face, even though Marathon is arguing, yeah, but 50% of it is really not a risk we ought to be facing.
correct. In that situation, honestly, you're 1% off. If Marathon certainly has a risk of 51%, and then they're on the hook for the whole thing. And that's the risk that they were indemnifying against.
It seems like you might also need a finding of how much the damages were, so that then you can gauge how much of the case Marathon settled. They, as one defendant, they would have perhaps settled only a portion of the case, and so then you would use that fraction to figure
So-
out how the rest of the numbers work.
So the entire case was settled. Opposing counsel has highlighted this sort of reservation language about ISI. That was specifically so we could pursue this indemnity obligation that they had. The plaintiff didn't have a claim against for damages. The workers' comp bar applied. There was no claim by the plaintiff against ISI, no tort claim, simply workers' comp benefits. So I want to just brief.
Aren't
Go
there
ahead.
other ways to contract away this risk where everybody is understanding, like an owner-controlled insurance plan, or other ways than what Marathon is seeking here? Because here, did ISI know when they entered into the indemnity agreement that they would be responsible for a portion of Marathon's settlement of the claims against it under this theory? And what in the contract would have alerted them to that?
So the contract has to mean something. These are two sophisticated parties, and they were contracting. They waived the workers in the contract, in the indemnity contract. They waived the workers' comp bar. They knew they were indemnifying for something. They knew they were doing it under the workers' comp statute. So under their theory, number one, of course, their theory is that if we settle, we forfeit the right for indemnity. They also argue that if we are less than 51% liable, there is no indemnity. We agree with that. That's the way the contract's written. Then they also argue that if we are joint and severally liable, 51, 60, anything, there's also no indemnity. That's not a reasonable construction of an unambiguous contract. The to the extent language, first of all, this court held in a somewhat different context that that's not ambiguous language. Except means excluding, to the extent means the degree. So it's, several courts that we have cited and other jurisdictions have said that to the extent language just explains that that's to the extent of our negligence. It is a comparative fault sort of thing.
If Marathon had not settled and the case went to a jury verdict and the jury found Marathon to be negligent and the amount was $86 million, would Marathon be able to seek indemnity under the contract?
What percent negligent?
You tell me if
So
under
I will,
80 percentage.
I will
would
tell you.
Marathon be able
So
to seek indemnity?
if negligence, if Marathon was found 40% negligent, we would be on the hook for 40%. I can't do the math, but 40% of the 86 million.
No. If your 40% totaled 86 million,
Oh,
the jury awarded
okay.
more than that.
I see what you're saying. I think that the settlement amount is the amount that's at issue here because we didn't go to trial. If we had gone to trial, then it could have been less, it could have been more. That's what settlement is about.
Okay, but would you have had a claim for indemnity?
We would have had a claim for
After jury
indemnity over and above our percentage of responsibility. So if we had only been found 25% liable, we did not contract for indemnity for our own negligence. And if we're only on the hook for the amount responsible for our own negligence, we don't get indemnity for that. However, if we have to pay for amounts that were not caused by our own negligence, that's what we get indemnity for.
So if the jury assigned 51% or more to use Marathon, making Marathon jointly and severally liable, and Marathon ended up having to pay more than 51%, your argument would be then you would have a right to indemnity for that excess amount.
Correct.
Okay.
Any other questions? Thank you, Ms. Maddox.
Thank you.
Ms. Barger, I believe you have 5 minutes.
I would
Can you
like to
think of any examples where a trial court has discretion on the result, but it's an abuse of discretion if the court doesn't use the correct standards in reaching that result? And you can send, either of you can send a letter on that if you think of something later. I don't want to put you on the
Yeah,
spot.
Your Honor, I would like to do a letter brief on that, because I think that is a really good question. If there's certain situations where perhaps the standard was misapplied and it would be an abuse of discretion, I would like to submit a letter on that. I think that would work. I would like to turn to a question. I was going to start with a question that Justice Bland asked. What would the contract look like, or how could they have done this? I think that's what should have been done. On the merits, they could have contracted around Ethel. They could have contracted around Jenkins. They could have added language like concurring or joint, or made it more express for the concurrent negligence.
Would your position be the same, though, if this case had gone to trial and Marathon ended up having to assume the liability of a party that was found responsible because they were found jointly and severally liable, even though their percentage contribution to the negligence was something less than that?
I think the result, like, let's assume the underlying trial would have gone. I think the express negligence test or Ethel would still apply because of what Marathon is seeking. What Marathon is seeking is not just for the negligence of ISI, but for all the other contractors. And I think that has to be expressed, and I think that should have been expressed. So I think if you go back and look at whether what is the intent, what are the parties believing?
If Marathon ended up becoming liable in a judgment for its percentage negligence plus a proportion of the percentage found against ISI as a responsible third party who will not have to pay the judgment, would that amount be indemnified under the agreement?
That's no different than they would have the right under the normal comparative or contribution statute as another party that, that's what makes it no different than the common law. So the provision itself, the indemnity provision, is no different than what Jenkins said. So this scenario.
So you'd agree there that they
Yes.
could sue for contribution?
Yes.
Okay.
Despite the workers' comp bar?
Does ISI have the workers' comp bar?
Right. Would ISI, without the contractual agreement, would ISI be liable for contribution to Marathon if there, under the scenario you were just discussing with Justice Bland, if there were no contractual indemnity agreement?
Let's assume that if the parties went to trial and a joint and severally liable defendant was hit for over 51%, that joint and several liability defendant under just the regular comparative Chapter 33 would have a right to seek against any of the other defendants if they could recover. If that's what you're asking.
But that's my question, is could they, so if it was 51 Marathon, 49 ISI, let's say ISI as an RTP, a responsible third party.
Not against an RTP, because
That's
yes.
my question. So there was no right to recover from ISI here at all because of the workers' comp bar. But Marathon wants to submit ISI as a responsible third party. So let's say that happens and the jury comes back 51 Marathon, 49 ISI. Marathon has to pay all 86 million or 100 million or 50 million or whatever the number is. They have to pay it all because they're jointly and severally liable. In the absence of any kind of indemnity agreement, would Marathon under Chapter 33 have a right to get indemnification or contribution from ISI under those circumstances?
Under the indemnity agreement?
No, there is no agreement.
Okay, they're under the RTP?
Yeah. You got a workers' comp bar that prevents that, don't you?
There is the workers' comp bar that applies, and I think that was raised by my opponent, in which what they were saying the legislature has 417007. So there is these agreements for employers, but the intent of the parties is to make sure that the scenario, when there is an agreement in place, you know what you're indemnifying for. And so I'm not sure if I'm understanding the question correctly. Would they, because there's the comp bar, they would have no recovery? Well, not all. Now there was one plaintiff was
The only reason
Not barred by the
Marathon has even the possibility of recovery against ISI here is the contractual indemnity agreement, right?
If it were a true contractual indemnity
That's
agreement,
what I'm saying.
yes.
If there were no language in your contract at all that required indemnification, it was just not in there at all, that you all know, that your clients never contractually agreed to any indemnification, and this scenario had arisen, plaintiff could not sue ISI because of the workers' comp bar, but they could sue Marathon. They sue Marathon. Marathon names ISI as the RTP. Says, well, we didn't cause all this. ISI caused this. Jury comes back 51-49. Would Marathon have any right based on statute? There's no contract, so it'd have to be said. They'd have no right to recover
They have no right to-
contribution
That is correct,
or
Your Honor.
indemnity of any kind from ISI. It's all based on the contract.
That is correct, Your Honor.
Yes, okay.
Any other questions?
One last question,
Yes.
Chief. I just want to understand, can you articulate then what work is the except to the extent phrase doing there? Because I have a sense, or when would this provision in Romanet 13.1 sub 1, Romanet 1, when would it operate then? Because I feel like your theory sort of rewrites except to the extent for, but this does not apply if there is any negligence by Marathon. So what's your theory of when this contract provision actually takes effect?
I think the apply, even if the express negligence test, even if it didn't meet the test, I think it could still cover liabilities for claims under which Marathon was vicariously liable, but it wasn't itself negligent. I think that's one way that this would be operative. That would be one example of when it would apply. And I think that there's many of these agreements, Your Honor, in many of these cases where the indemnity agreement hasn't met the test. And that's the whole point that this court has said in many of its precedents. I would like to answer one question.
Yes.
Chief Justice Hecht, the intent of the PFR, the question asked before is, I think that's a little bit different just because here the legislature decided to expand the permissive appeal in the interlocutory appellate statute. So the whole point is to expand things, and the PFR process and procedure is much different than that.
Any other questions? Thank you, Ms. Barger. The case is submitted, and the court will take a brief recess.
All right.